During the course of your medical malpractice lawsuit, the defense wants you examined by a doctor of their own choosing. But there's a problem. The doctor can't come in and testify. And now the defense wants to go ahead and do a video deposition of the doctor who examined you to now present it at trial. Can they do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. So now you've brought a lawsuit against a doctor claiming that he violated the basic standards of medical care, causing you significant injury. Well, now you bring a lawsuit, and during the course of your lawsuit, the defense has an opportunity to have you examined by a doctor of their choosing. And the whole purpose of having you examined by one of their doctors is to assess your current medical condition. And you should know that the majority of the time, these defense doctors come in and say, oh, no, you're not as badly injured as you claim you are. Their whole goal is to minimize the extent of your injury. Why? To try and limit the amount that they'll ultimately have to pay if they're legally responsible. So now, if the doctor who examined you is not able to come into court for whatever reason, the defense may in some cases try and preserve that doctor's testimony, and the way they do that is by questioning him during pretrial testimony. And there's a whole process and a procedure in order to allow the defense to go ahead and do that. But they may have a valid reason saying, listen, we want this doctor to come in and testify, but he's going to be out of the country, or he won't be available at the time of trial. So now we'd like the opportunity to question him, and we're giving you, the plaintiff, the opportunity to cross-examine him during this pretrial testimony process. So now we can use that testimony at the time of trial. Will the judge allow that to happen? In all likelihood, yes, if the defense can give a valid explanation and a valid reason why the doctor is not available to come in and testify at the time of trial. Now, do I have to be there? The answer is yes, I do. If they're going to question the doctor during pretrial testimony, it is the same as if we are at trial. The only difference is that we're doing it in the attorney's office, and there will be a court reporter taking down all the questions and all the answers that are given. And ideally, they will want to have this videotaped so that the jury can actually see as well as hear exactly the questions that are being asked and the answers that are given. So now, after the attorney, the defense lawyer, is done questioning their own doctor, I then have an opportunity to cross-examine the doctor the same way as if I am at trial cross-examining him. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what can happen during a medical malpractice case here in the state of New York. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you're thinking about bringing a lawsuit, but you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Jerry Oginski. Have a wonderful day.